Hi, y'all, and welcome to tonight's live stream. We are less than 2 weeks away from a bombshell hearing in the Alex Murdaugh case. Alex Murdaugh was convicted of murdering his wife Maggie and his son Paul. Alex Murdaugh admits he's a criminal, guilty of a host of financial crimes, but he wants a do-over on his murder trial, and he may just get it. We are going to be talking about that tonight. For the judge has announced that there will be a hearing and asked both sides to file briefs outlining what they want to happen at the hearing. Now, the state apparently filed theirs under seal, but Alex Murdaugh, his side did not. And we are going to take a look at the roadmap Alex Murdaugh has given us when he filed his detailed plan for the new hearing and what he wants to do. So happy Monday, everybody. For our regulars, you know that we are in the middle of covering the Michelle Troconis missing mom murder conspiracy trial. The Troconis court took the holiday off, and thank goodness, because it gives us a chance to do a critical update in the Murdaugh trial tonight. We'll be back on the Troconis trial tomorrow and every night this week. So this is going to be an absolutely fantastic week, I think, for the channel. I have 2 more Murdaugh videos and a Richard Allen Delphi video all in the works, getting pretty close to drop. So absolutely be sure to subscribe so you get notice when they come out. And I would really appreciate it if you would hit the like button. That helps this video get out to more people. So the document that we're going to be looking at tonight is a brief filed by Murdaugh's team. The judge asked him to file a brief ahead of tomorrow's scheduling conference. That way it would help her plan for the hearing, which is going to be at the end of the month. This is the defense brief that outlines how they want the hearing to go, what exhibits they'll use, what witnesses they'll call. It really gives us the roadmap, what they think is in store for us. So let me add that to, give me just a second. I will add that to the stage. And I need to make just a few adjustments, so give me a second. I am still working on my adjustments. Give me another second. All right, I'm still working. It won't be but a minute. I just want to make this a little easier to read. Okay, so let's get started at the beginning of this. And we're just going to read the highlighted parts. It was, as you can see, 32 pages, so that's really long. I didn't think we had time for that. But what we'll do is just read the highlights that I talk about. So this is Alex Murdaugh saying his motion. Alex's motion alleges that Rebecca Hill, we call her Becky Hill, the elected clerk of court for Colleton County, had extensive private communications with members of the jury during trial. Mr. Murdaugh alleges that an elected state official, that would be Becky Hill, deliberately violated his constitutional right to a fair trial before an impartial jury. If that allegation is proven, the law requires a new trial. So this represents, and we'll read just a little bit further. On January 4th, 2024, the court instructed the parties to resubmit their briefs answering the following questions directly. And I wanted you to notice this one particularly. Specifically, clarify the argument you will make during the evidentiary hearing. I've already decided an evidentiary hearing will occur. The mere fact that I have set the matter to include an evidentiary hearing does not mean I have decided any issue in the case at the present. But already, this represents a huge win for Alex Murdaugh. The judge has ruled that there will be an evidentiary hearing. Up until now, the state has been arguing that there's no need for a hearing, that the court could just note that the individuals were individually polled at the trial. They agreed that their verdict was guilty. That's all the court needed to know. Now, Murdaugh's whole motion for a new trial would be dismissed if the state had its way, but the judge has already ruled that there will be a hearing where evidence is presented. And that means an evidentiary hearing just means evidence gets presented, witnesses, documents. It's not just a hearing where the lawyers argue their points. People had already figured that much because after all, the court set aside 3 days. And even though lawyers do like to talk a lot, arguing over one issue for 3 days is excessive, even for lawyers. But just because there's a hearing, that doesn't mean that Alex Murdaugh is going to get a new trial. After the hearing, the judge will decide whether Alex Murdaugh gets a new trial. The point of the hearing is to help the new judge, Judge Toll, make that decision. So let's keep reading. This is a criminal case, but the instant motion places Mr. Murdaugh in the position of a plaintiff in a civil proceeding. Mr. Murdaugh needs discovery because he has an affirmative case to prove. Mr. Murdaugh must make 2 showings by a preponderance of the evidence. 1, extrajudicial contact or communications between jurors and unauthorized persons occurred, and 2, the contact or communications pertain to the matter before the jury. Yet it is the state and not Mr. Murdaugh which has had the opportunity to conduct discovery for the past several months regarding Mr. Murdaugh's claim using the tools available to law enforcement. So what's happening in this section is Alex Murdaugh is saying, look, you're asking us, Judge, to list the witnesses, to list the documents. That's really hard for us to do. Normally in a case, whether it be civil or criminal, there's some discovery and we get some information from the other side, and there hasn't been the chance for that to happen here. So we never got to ask witnesses questions unless they voluntarily agreed to talk to us, like some jurors did. We never got to depose Becky Hill. We never got to force her to turn over documents. And they do have a point. The state has been getting information through the criminal process, and Alex Murdaugh is at a disadvantage there. But that's just the way it is here, because getting a new trial is a very unusual remedy. It's up to Alex Murdaugh to prove that he's entitled to that. So he bears the burden of proof, and that's why he's having to do this. Now, this next section we're going to look at is probably the juiciest of all. We're going to get a direct insight into the witnesses the defense thinks are the most important, the ones Murdaugh thinks will help him get a new trial. And some of these witnesses add a lot of drama to this hearing. Now, the witnesses are divided into 2 sections. So what I'm going to show you is there's a will call and a may call section. We're going to start going through them. I'm going to do a whole separate video on this because I want to tell you sort of in detail who these people are. What is it that they know or might say at the hearing? But we're just going to do kind of a quick overview right now. Now, if you're an attorney and you put a witness on the will call list, what you are saying is, we definitely are going to be asking that witness to testify. We're going to send out the subpoena. We're going to be calling that person as a witness for sure. Now, may call, that means what it sounds like. We might need this person as a witness. We'll just have to see how things go. We don't know for sure. We're not promising that we're going to call them. We just might. So let's take a look at what the jurors, they have 4 jurors on here, and we'll be talking about those in the next video. Rhonda McElveen, Barnwell County Clerk of Court. So she's from another county, a clerk of court who helped with the case. Aubrey Hill, that is Becky Hill's daughter. Creighton Waters, and boy, that's a bombshell, huh? Creighton Waters, because he's the prosecutor who prosecuted Alex Murdaugh, they are saying is going to be called as a witness. Now, I will say, do you see where it says January 12, 2024 supplemental response here? I really think that they meant to put these witnesses under may call because all of them seem to have to do with Becky Hill and the response to Becky Hill. We'll see. But so I don't know. They put them under may call, but that may just have been a mistake. They may have just, they put them under will call. They may have meant that they might call them, but they don't know for sure. But anyway, Creighton Waters, the prosecutor, being called as a witness, and there's some good reason for that. There's some emails he exchanged with, an email Becky Hill sent to him, 2 of them. And so that's what they probably would ask him about. Carly Jewell, who is a paralegal in Creighton Waters' office, or at least who worked with the state in the case. And so she's also listed. Now, for now, I just want you to notice a couple of things. First of all, only 4 jurors are listed, not all 12 and not 13, which would include the ed juror. Just 4 witnesses are listed. So, and also note that Aubrey Hill is added, the daughter of Becky Hill, and Creighton Waters is being added. Now, I will say this. courts really, really frown on calling the other side's lawyers as witnesses. I mean, it's pretty obvious why, right? I mean, it creates a lot of animosity and injects all kinds of bitterness and arguments into the case. And other lawyers, or some lawyers, might be tempted to call the other side just to get even with them in a particularly bitter litigation, which, let's face it, this definitely is. So, but in this case, all of these witnesses know about the Becky Hill allegations, which is why I think they may have been put on they may have intended to put them on the may call list if Becky Hill comes. And we'll go ahead and read that. Two other people, David Owen, lead SLED investigator, Rachel Joseph, another SLED investigator. And then they say the state must call Miss Hill, Becky Hill, to deny the allegations that she tampered with the jury. Depending on Miss Hill's testimony, Mr. Murdaugh might call some of the following witnesses as rebuttal witnesses. And they name more people. Laura Hayes, former deputy clerk of court in Colleton County. Jeffrey Hill, former IT director for the Colleton County Courthouse. And we know that that is Becky Hill's son. So if all of these witnesses end up testifying, it will be both Becky Hill and both of her children. The Honorable Clifton Newman, retired circuit court judge. They are calling the judge, or they say they may need to call the judge from the case where Alex Murdaugh was convicted of murdering his wife and his son. Tim Stone, the ex-husband of juror 785. That is the ed juror. We have a whole video on that. That is absolutely fascinating. You definitely don't want to miss that. I'll link it at the end as soon as I'm able to. It takes YouTube an hour or two to process the video, and then I can add the link. Timothy Stone, original poster of the Facebook message. If you remember the ed juror, you'll know what that's about. And Lori Weiss, employee of the clerk of court in Colleton County. So if this hearing goes full bore, that is a lot of witnesses, all of it circling around the issue of whether Becky Hill either needs to be impeached or was directly tampering with the jury. We're going to read a little further. The parties were also asked, list any objections or challenges you plan to make to opposing parties' witnesses. And this is actually interesting because it's a shift for Alex Murdaugh's side. Mr. Murdaugh believes the state will call jurors, bailiffs, and court staff who were never, or almost never, in the jury room in which Miss Hill made her jury tampering statements to present a cascade of witnesses saying they never heard Miss Hill make inappropriate statements in the jury room, to imply by false logic that she therefore did not make such statements. When the jurors retired from the courtroom during trial, they spread across two different rooms. Jurors, and they have a bunch of numbers, were in the actual courthouse jury room. Miss Hill made her jury tampering statements to jurors in the jury room. The others, they say, were in Judge Perry Buckner's office. Mr. Murdaugh has no objection to the state calling other jurors who were in that room to testify that they never heard Miss Hill make inappropriate statements. But Mr. Murdaugh objects to calling jurors who were in a different room to testify that they never heard Miss Hill make inappropriate statements. Their testimony is not probative. So in the motion that Murdaugh filed originally, he put in affidavits from two jurors who were in that other room. But at that point, the Murdaugh team was not able to talk to most of the jurors. So they are now shifting. At that point, they had said most of the jurors wouldn't talk to them. Now SLED has gone out and interviewed all the jurors, and it became pretty clear that Becky Hill interacted a lot more with the jurors in the jury room, not in Perry Buckner's office. And those jurors were, I think, all women. So here's what Murdaugh's worried about. He's worried that the state is going to bring in dozens of witnesses who say, oh, no, nothing happened. And just after 150 people say nothing happened, it's going to look like nothing happened, even if for the people who really matter, something did happen. And they're afraid that it's going to drown out the voices of the people who have real information. I say, if you get enough people, you're going to make it look like a small problem, but it wasn't. So they want the court to narrow the juror list to just the jurors in the jury room. And like I say, that would even leave off one of the witnesses they thought was most important back when they originally filed the motion. So let's keep reading. Okay. If the state objects to her testimony, Mr. Murdaugh would ask, and we're talking about now Becky Hill. If the state objects to Becky Hill's testimony, Mr. Murdaugh would ask the court to review her video recorded interview with SLED and decide for itself whether her testimony would assist the court as fact finder. If the court does so, however, it's important to review the video recording of her entire interview and not the SLED memorandum summarizing it. As explained in the discussion of the mode of witness examination, info later, the state's memoranda summarizing witness interviews are sometimes grossly inaccurate, and when they are, it is always in a manner that favors the state. Now, one of the interesting things that comes out in this brief is a window into just how much the animosity between the two sides has gone to really high levels. We all know that the Murdaugh side does not trust SLED or the state, and they don't want the judge to just accept their summaries of the witness interviews. So we're going to do a quick tour through Murdaugh's argument on what the standard should be. It's more fleshed out than it has been in the past, so it's pretty clear now what they want. I'm saving that pink for later. One of the next videos will be talking about that. Okay, Mr. Murdaugh does not need to show actual bias on the part of any juror to obtain a new trial. And the argument that the Murdaugh team is making comes through here, where there was the private communication of the court official to members of the jury, an occurrence which cannot be tolerated if the sanctity of the jury system is to be maintained. A new trial must be granted unless it clearly appears that the subject matter of the communication was harmless and could not have affected the verdict. The law requires the subject matter of the communication be harmless, quote, clearly harmless. So, and we know that the Murdaugh team and the state differ over what they think the standard is that the Murdaugh team has to prove. Everybody agrees Murdaugh's got to prove something, but what? What exactly does Murdaugh have to prove? So the Murdaugh team thinks it's enough to just prove that the clerk of court had private communications with the jury about the case, not just something harmless like what time is lunch going to be or how soon will we break, something about the case. And that's the Murdaugh position. The present case, and they're now going to talk about what the prosecution is arguing. The present case is different because a state official instructed jurors how to view the defense case outside the presence of the court, the defendant, and his counsel. Deliberate jury tampering by a court official cannot be cured or excused by the strength of the evidence presented at trial or jurors offering their own subjective opinions regarding their own biases. Even if every juror were to testify that he or she would have reached the same verdict regardless of Ms. Hill's tampering, a new trial is required if it's proven that Ms. Hill communicated with jurors about the merits of the evidence presented. So what the prosecutors want the jurors to come in and say, we would have been fair. We thought he wasn't guilty. It didn't have anything to do with Becky Hill. But the Murdaugh team thinks, if there was just this communication, it doesn't matter whether the jurors think it made a difference because you can't count on people to know whether or not they've been influenced. And let's look at the reason why. And they quote a case, Parker v. Gladden, where a bailiff told a juror, that wicked fellow, he's guilty. And the Supreme Court of Oregon said, you don't need a new trial. It didn't make a difference. But the U.S. Supreme Court reversed that. And here's what they said. The evidence developed against a defendant shall come from the witness stand in a public courtroom where there is full judicial protection of the defendant's right of confrontation, of cross-examination, and of counsel. So something that Becky Hill tells the jurors privately is not in the courtroom. So the judge doesn't get a chance to rule on whether whatever she said is admissible. And the defense doesn't get a chance to object or respond. They can't appeal it. So all of those reasons are why it's so critically important that a member of the court staff, someone in representing the court, can't talk to the jurors. So now I want to give you just a little, I just highlighted these parts because I thought they were kind of fun. The state's response includes citations to several cases purportedly supporting its position, but not one cited case actually supports it. The reason why I thought this was funny, this is the more scholarly, like lawyer equivalent of second graders who are facing off in the lunchroom and telling your mama jokes. And this, both sides will do this. It's just very natural. Lawyers do this. Everybody stands around, ooh, gotcha. That was a good one. So I just thought they were entertaining. So I thought you would enjoy it. And I wanted to read them. And they talk about something the state said. That assertion only makes sense if the state did not expect the court to read the Cameron opinion. And finally, Mr. Murdaugh has no idea what Smith case the state believes more subsequently clarified the legal standard. The only Smith case cited in the state's response is Smith v. Phillips. I don't know why this is. Let me tell you what, I'll just throw that out. There we go. The irrelevant 1982 U.S. Supreme Court case discussed above that predated Cameron by 11 years. And as discussed above, Green reversed a Court of Appeals decision to correct its reasoning to bring it in line with Cameron. So they're saying there is no Smith case that happened afterwards. The only Smith case you talk about happened before. Anyway, I just thought that was, I thought you would like a little window into how attorneys bicker. That's the lawyer's way of bickering. That's how it happens. So let's read the next section. While the state could, in other circumstances, perhaps show, for example, that a communication was harmless because it was only heard by a non-deliberating juror. That means somebody who wasn't actually a juror, like Juror 785, the Ed juror, got thrown off the case on the morning of deliberations, but before they started. Where a state official's exhortations on the evidence presented at trial was communicated to at least one deliberating juror, the court cannot overlook the offense by speculating that the outcome would have been the same regardless. Now, honestly, I think I would have taken a little bit harder line on this if I were representing Murdaugh. I think that if the statements were made to someone who at the time thought they were on the jury, in this case, Juror 785 was in fact going to be on the jury had she not been kicked off. She wasn't an alternate. If that were the case, then I would think any comment to any of them, I mean, they're all sitting in the jury pool. They're all together. I would think they all ought to count. All right. So, but what's important is that the Murdaugh team is admitting for the first time that statements made to alternate jurors won't count. And up until now, there hasn't been an admission about that. Becky Hill had to be talking to jurors who actually sat on the case and delivered the verdict. Like I say, I don't agree with them on that, but and it's amazing, truly, that they agreed on that because the Ed juror was one of their most important set of facts when they first filed that motion for new trial. It was one of their biggest allegations. So I'm kind of surprised to see them back off a little bit on that. And they really didn't address a lot of that here, but they are going to explain why they think the Ed juror information should still come in, why they think it's still important, even though she actually didn't sit on the jury. And we'll get to that as we go a little bit further down into the motion. Mr. Murdaugh will argue that a preponderance of the evidence shows Ms. Hill made statements to at least one deliberating juror about the merits of the evidence presented at trial. And they talk about Juror 630 will testify that Ms. Hill should not be fooled by the defense and they should watch her body language. I'm not going to go into detail, but they talk in this section, and I'm going to save that for the other video that I'm going to do. They talk about what it is that the jurors are going to say and why they think these jurors are going to prove their case that they ought to get, that Murdaugh ought to get a new trial, a new murder trial. So, and I'm going to skip all of that just for time purposes. Mr. Murdaugh requested the court issue a subpoena. Now they're going to talk about all the procedural issues. They want a subpoena for each of the jurors and witnesses identified. And they believe good cause exists for the court to conduct the examination. Oh, I know exactly what happened. Just a second. I think I pulled up. Nope, that's the resubmission. Okay. Sorry. Just a moment. I was like, wait a minute. I don't think I highlighted that section. All right. So Mr. Murdaugh previously took the position that jurors should be examined by the court rather than by counsel, with the court accepting suggested questions from the parties. Now, that was something I thought, you may remember in some of the earlier videos, I said, I don't think that ought to happen. I think the lawyers ought to ask the questions. I just think that's the way it should be. But they were saying, both sides were saying that they wanted the court to do it. But now Murdaugh's team is backing off that. And they're saying, after receiving SLEDs, video recordings, and summary memoranda of juror interviews, Mr. Murdaugh's counsel are concerned that the court may not have sufficient information to examine the jurors effectively. And they go into an example of why they think that might be. They're saying that the court would need to watch the entire SLED interview for each testifying juror. And that would take a whole lot of time, given that we're just 2 weeks out from, less than now, 2 weeks out from the hearing that the court wants to hold in this case. So they're saying, look, this is going to be a whole lot of work, and it makes a lot of sense for the lawyers to do that questioning. Now, and I do agree with that. I think that makes a lot of sense. So the state argued that the court should question them with a mind to at least the number of jurors exposed to the improper communications. And Murdaugh is arguing that's irrelevant, as long as it's one deliberating juror. I really agree with that. The state is saying, well, maybe it had to be a majority. I mean, I don't think they made an exact number, but if it's just one, maybe that isn't big enough. I think if somebody representing the court, a court official, made communications about the substance of the case to any juror, I do agree with the Murdaugh team on this. I think that's a really important, big deal. And I think that ought to be enough right then and there for him to get the new trial. And then there's the very touchy issue of Judge Newman testifying. That is so awkward. He's now retired, but a very well-respected jurist. And the Murdaugh team says, well, if testimony is needed from him, Mr. Murdaugh believes it should also be conducted by the court in camera to preserve the dignity of his judicial office. Now, I said I don't agree with that, because Judge Newman was a public official, and for the sake of openness, I just think he should want to testify openly. I think he should ask for that. But I understand they're wanting to be gentle about it because it's going to be controversial within the bar. But I do think that's really the right thing to do. I think it needs to be public. Okay, and now we're going to talk, they talk a little bit about the fact that who's going to ask the questions? Is it going to be the court, or is it going to be the lawyers of the two sides? And they're saying the default, that's where the lawyers ask questions. But Mr. Murdaugh does not believe good cause exists to reserve the examination of any witness to the court other than Judge Newman and possibly the jurors. Ms. Hill especially is a witness against Mr. Murdaugh in a criminal case whom Mr. Murdaugh has a right to challenge in open court. And I will say, I 100% agree with this. I think the lawyers need to do the questioning. Our whole system is based on the idea that the very best way to reach the truth is for one side to come in and do its best to prove what it thinks is right. And then the other side comes in and argues just the opposite. And the way the person makes the decision is they see both sides of it. And you get the two sides clashing, and that helps the judge, the jury, whoever is making the decision. That gives them all the tools, all the information they need to make the decision. So I do agree that it makes more sense for the lawyers to ask the questions. They're also the ones who are prepared, and they prepare from their side so they can ask the right questions. But notice something they did not mention here. They did not mention specifically Creighton Waters. They've listed him as a witness, and they don't accept him and say the judge ought to ask him the questions. So that would mean that Dick Harpootlian or Jim Griffin would be cross-examining Creighton Waters. Let me know what you think about that in the comments. I am really curious in the chat. What do you think about the idea of Jim Griffin or Dick Harpootlian cross-examining Creighton Waters on the stand? Would you like to buy tickets for that, or do you think it's really improper? Just let me know your thoughts on that. I can tell you this, the judge is not going to be happy about that idea. It's going to be something the judge will resist. There will have to be a lot of proof that it's important and absolutely necessary. So now we are about to get into what is going to be the most interesting part of the hearing. We are going to get into what Ms. Hill will testify about. And the Murdaugh team throws out this little interesting bit here in a footnote. If the court were to decide Ms. Hill's testimony cannot be credited, her testimony would not be relevant to any issue, and Mr. Murdaugh would have no right to examine her. And what they're saying is, if the court will just go ahead and rule with us, if the court will just go ahead and say, I'm buying what the jurors say, I'm not really buying what Becky Hill says, so I'm not going to agree with what she said, well, then Becky Hill is not relevant. And that would also be true of all those make call witnesses who were responsive to Becky Hill. None of them would matter. There would be no need to examine her, to ask her questions. And what would they ask her about? They talk about her emails, Ms. Hill's emails, text messages, telephone records, testimony from court staff, etc., persons involved in the production of her book. I was surprised that her co-author was not listed as a witness, nor was his wife, who had done some photography work for them. It includes evidence related to her complaints against Ms. Hill and the results of investigation into Ms. Hill's wrongdoing. And I'm not aware of any results of those. There are definitely rumors that there are 2 ethics or criminal, but criminal complaints by SLED against Becky Hill, but only one of those has been made public. So I'm not aware of either one having any results, but I thought that was very interesting. It includes evidence related to her involvement in the removal of juror 785. This is how they're pulling the Ed juror back in, even though they're saying they agree that if the juror didn't sit on the actual jury, then it won't count. But nonetheless, Ed juror ought to come in, and here it is. Not because the removal itself is grounds for a new trial, but because juror 785 has sworn Ms. Hill was involved with her removal in an improper and dishonest way that, if true, would serve to impeach Ms. Hill's credibility. So they're saying the reason that juror 785 is important is because it shows Becky Hill was dishonest and therefore can't be trusted. It's not that it specifically goes to whether or not there should be a new trial in and of itself. Ms. Hill was sending emails direct, and this is why Creighton Waters would be called. Ms. Hill was sending emails directly to prosecutors and law enforcement witnesses for the state during trial about the merits of testimony from defense witnesses under examination at that moment. And I'll talk about that more in the video I do about the witnesses. I'm going to skip to the next sentence. So long as the court is prepared to give Ms. Hill's testimony any weight, her lack of credibility is not established, and evidence impeaching her cannot be considered cumulative or repetitive. So they're arguing, look, if Becky Hill is going to come in and you might believe her, then we get to throw in the kitchen sink. We get to give her everything, all the things that prove that she lied or that suggests that she did something wrong. We get to throw all of that in, and it's going to be quite the battle. Now, the judge is going to cut back on that, would be my guess, as it's going to say some of this stuff is irrelevant. But they're saying, as long as you're still thinking that you might believe her, then we ought to be allowed to throw in whatever it is that will convince you not to believe her. And that's what they're going to argue. Right. And now here's a little more on the attorneys battling each other's side. Counsel for non-parties, meaning in this case Eric Bland, should not be permitted to participate in these proceedings. He seeks a level of non-party participation beyond what even crime victims would get. And here's a little tattling. Mr. Bland stated on his podcast, Cup of Justice, that Justice Toll, she's the new judge appointed in the case, the newly assigned presiding judge in this matter, has friends sometimes to reward and enemies to punish. And I worry about what procedures are going to be put in place. The fact that there was a status conference, and I represent 4 jurors, and I wasn't even told of that status conference. And I believe that my jurors have the right to legal representation in any type of proceeding dealing with Alex Murdaugh's verdicts where they're going to have their verdicts questioned. And this is Murdaugh talking again, his stated intent is not to protect the personal interests of his clients as witnesses, but to advocate to sustain, quote, their verdict. The jurors are simply witnesses with no more right to participate in this criminal proceeding than witnesses in any other criminal case. It would defeat that purpose if the proceedings were allowed to devolve into a speaker's corner for lawyers who want to appear on television even more than they already do. Now, Fitz News was speculating about whether the South Carolina bar would sanction Eric Bland for his comments. I will say this, I hope not. I think everybody should be allowed to express opinions about public servants, and that includes, in my mind, judges. I think that's a First Amendment right that we want to protect. So I did not hear these comments, but it really does surprise me if Eric Bland actually said that about Justice Toll, just as it's quoted here, and it wasn't taken out of context. I don't understand why he would say that. I don't understand how it helps him or helps his clients. It makes me think he does have real concerns about whether she would be fair, but she's a retired Supreme Court justice, and her colleagues respected her enough to appoint her to this obviously very difficult, very controversial, very political case. Now, I don't practice in South Carolina, so maybe definitely, there's more to this than meets the eye, but I do wonder about that whole situation. I would also agree with this on the Murdaugh side, that it's not their verdict, it's the state's verdict. And the state has to defend it. It's not up to the individual jurors to defend their verdict. They have personal rights as witnesses, and that's where Eric Bland or any other attorney will represent them. To the extent there to be consequences for how they acted as jurors, or to the extent they testify at the hearing, they're entitled to have an attorney represent them in their capacity as the witness or as the juror. And I can see where there are important things that Eric Bland would have to say about, for example, who questions the jurors, about whether they're questioned in public, whether their names are identified. But that may be all he wanted. It's hard to know. Now, obviously, Murdaugh's team felt like he was going to take it further than that. So, and they are now about to go all in on Becky Hill. They are ride or die on Becky Hill, and you're going to hear that in this next section. By the way, I'm coming toward the end, so I'm going to answer questions. If you have a question, be sure to put that in the chat, and it will really help me if you could put several question marks in, preferably at the beginning, but just put several question marks in so it's a little easier for me to spot. All right, so let's head on down for the last bit. Ms. Hill likely is the only witness the state can offer who can directly contradict Juror 630's averments of jury tampering, and Ms. Hill has offered an affidavit doing exactly that. Her credibility is the crux of the matter before the court. The purpose of the evidentiary hearing is to allow the court to decide whether it believes the word of Ms. Hill more than it believes the sworn testimony of one or more jurors. Anything that impeaches Ms. Hill is relevant, and the state's rhetoric about Ms. Hill being a dedicated public servant, unfairly maligned, that means spoken badly about, has not aged well in the 2 months since the state filed its response, to put it mildly. Ms. Hill is alleged to have stolen money, illegally sold access to the courthouse, conspired with her son to conduct illegal wiretaps, and even had her book removed from publication because of her plagiarism. And for real, there is a lot going on with Becky Hill. That is absolutely the truth. So let me remove that from the stage, and then I can come out and finish up. So this is an absolute make or break hearing for Alex Murdaugh. His number one best bet of getting out of the murder convictions is a new trial. And this is it. It is all going to come down to this hearing. The hearing will be the 29th through the 31st of January, and we absolutely will be covering it. So be sure to subscribe. Now let's take a look at what some of the questions have been. All right, Annie K wants to know about Alex Murdaugh's attorneys grandstanding, interfering with real issues. How can Waters be called as a witness if he's the prosecuting attorney? Are they trying to get him off the case? Great question, Annie. And the way he would be called as a witness is that this is my guess anyway. There was an email that Becky Hill forwarded to him where people were submitting in the middle of trial suggestions to the prosecution. And she sent those emails on to Creighton Waters. And I think that the defense is going to say that was that was Becky Hill actively lobbying, working on behalf of the prosecution. Should the clerk of court be actively working on behalf of the prosecution? Shouldn't the clerk of court be neutral in the case? This, I think they're going to argue, indicates she has a real bias, that she is trying to help the prosecution at Alex Murdaugh's expense. That is because he received those emails, at least in theory. That may be why he would be called as a witness. I'm just guessing. I'm just throwing that out there. I'll talk about this a little bit more when I get to that video I'm going to do about all the witnesses in the case. Would they try to get him off the case? That would definitely be possible as far as the hearing. I don't see why that would keep him from prosecuting Alex Murdaugh again. Even if he had some kind of contact with the clerk of court in the first trial, I don't know that that would pull him off the second trial. We would just see what happened with that. Karen wants to know, will the Ed juror be brought back to testify? I think the answer is yes. The question is whether the court is going to decide that's relevant. The court might say, all right, I'm only going to let in these 6 jurors who were in the jury room. I'm not going to let in any alternates who didn't sit on the jury. And in that case, the whole argument about the Ed juror, her husband, her not husband who was posting on Facebook, all of those things would be irrelevant. But we don't know the answer to how the ruling will be yet. I think the Ed juror, well, they do want to bring the Ed juror. That's something that the Murdaugh team wants to do. They want to keep litigating that. Morpheus is asking me whether Becky Hill could be criminally charged if there's a retrial or held in contempt. I'm thinking not so much contempt. Could she be criminally charged? Maybe. It really would depend on what exactly is provable that she did. Personally, talking to the jurors about the case, I'm not sure I see that as criminal. There may be statutes that apply to that. The things that seem to me to be a bigger issue for Becky Hill are the ones that relate to her using her position for financial profit or gain. There are allegations supposedly about that in the ethics complaint that is not public. So it's really hard to measure or evaluate how much that would be. To me, it would be as far as her interfering with the jury, from what we've heard so far, it sounds more like a level of just sort of a level that would be improper, but I'm not sure it would be criminal. It might be a reason why people wouldn't vote for her next time she ran for clerk of court, but to me, it's more on that level. But we are lacking a lot of information. Apparently, SLED has been investigating, and they will have a lot more about that than we have out here in the public. Dana wants to know whether I would give Alec a new trial based on the information provided. Well, Dana, I would want to. One of the things I've said is if all of the affidavits came out as they were written out, then it sounds to me like probably yes. What I would like to see, though, is a lot of times what somebody says in an affidavit is a little different from how it comes out at trial. So I want to make sure all of that holds up. So I would not really want to make a call on that until the actual testimony came out. And if the Murdaugh team gets its way, we won't ever actually see the jurors testify. All we would get is a transcript that would be redacted, assuming redacted any jurors' names. And so some of it, frankly, might be kind of hard to follow if there are all these redactions in it, but we wouldn't get the entire thing. Jersey Jen likes the information tonight. Great. I'm glad you enjoyed it. Good. Let's see. Is there anything else I have? Let's see. Has Becky Hill been suspended? No. As far as I know, she still remains the clerk of court, and there's no move to suspend her at this time. I don't even know what the procedure would be. I think that from something that was said in one of the briefs that there's a mechanism for doing that, for removing her. Oh, that was in a newspaper article. There's a mechanism for doing that depending on how far things go, but I don't think things have reached that stage yet. I don't think that's even an option at this time. And we'll do 2 more questions. Okay, Drew P wants to know, what is Alex Murdaugh's defense team's recourse if he's denied a retrial? They go back to their appeal. They were up on appeal. They were ready. They were in their briefing schedule. They were going to be doing the appeal. No briefs had been filed yet, but that was being scheduled. They were going to get the transcript up. They'd be doing all of the regular appeal they would have done from the first trial. What they would like is they lost that one. An appeal from a trial you lost is a lot worse than an acquittal. So what they would like to do is a new trial and a new chance. Maybe they win this time. And if they win this time, they're thinking no need for an appeal. So that's what they're aiming for, is the new trial. But if they don't get that, they still have the appeal from the first trial. That can still happen. And let's see, S. Cipher asked me, Creighton Waters, can they really cause him to testify? What about the client attorney information? So I think S. Cipher is saying, how can you ask the prosecutor to testify? I mean, isn't there some kind of attorney-client privilege that ought to apply to that ought to cover what he said? And the answer is that in general, you can't ask the attorney for the other side to testify. There's a limited amount of information here that Creighton Waters might have. All I know about that he might have is information about the email that Becky Hill sent to him. Maybe about conversations Becky Hill had with him about whether or not, if she was willing to send him information from the public to help his case, did she ever help him in any other way? I'm not aware of facts beyond that. And I don't think there would be any significant cross-examination allowed of Creighton Waters. I just don't picture the judge allowing much in that way. I think the judge would maybe let Creighton Waters answer, but what probably is more likely is that maybe Becky Hill, well, we'll talk about in another video I'm going to do, what is it Becky Hill is going to do? Is she going to take the fifth? Is she going to testify? So another solution to that, if the other side just stipulates that Becky Hill forwarded this email to Creighton Waters, the judge may say, well, what else do you have any business asking Creighton Waters about? What else does he know? That doesn't seem very important to me or very relevant. So I'm not going to let you ask him questions or put him on the stand, because the judge is not going to want to put him on the stand. I can absolutely guarantee you that. Oh, I want to thank Butterfly Keeper 99 for the super sticker. I appreciate that. Well, we have a ton going on this week. I'm hoping to drop several videos in addition to going live on the Michelle Troconis murder conspiracy trial. It's a huge week, so absolutely subscribe. You don't want to miss any of this. And I want to thank Marlon and Mama Pinks for doing our moderating. They always do such a great job and make it a friendly, happy place, which I really appreciate. So if you would, on the way out, be sure to hit the like button, and I will see you tomorrow night, Tuesday at 7 p.m.